How do I win a debt collection lawsuit? Well, winning a debt collection lawsuit depends largely on record keeping. And what type of records you keep depends on what type of lawsuit you're going to file. Normally, a lawyer will determine what type of lawsuit you're going to file. However, you as the consumer will be able to tell what type of records to keep based on what's happening to you. So, for example, if you're receiving debt collection calls on your cell phone, there's a federal statute that prevents these types of calls. Unless, of course, you gave the collector or the original creditor consent to call you. Now, that doesn't mean that they can call you nonstop. If you as the consumer want the collector to stop calling you, you could tell them to stop. And the type of records you're going to keep in that instance is the date and time and the individual from whom you revoked consent. So you're going to write down, I told Mary from collector ABC to stop calling me on January 1st, 2017. Then, if the collector continues to call you, you're going to keep a record of each subsequent time that they call you. January 1st, Mary from collector ABC called me. January 2nd, Mary from collector ABC called me again. And so on and so forth. This will allow your lawyer to put together a proper TCPA lawsuit and sue the debt collector and possibly even the original creditor. Now, if there's a specific problem with a debt collection letter or notice that you're receiving, this might fall under the FDCPA. The type of records you're going to keep there is, of course, any document that the collector sends you and any documents that you send the collector. So if you send a letter to the debt collector saying, please stop sending me these letters, or show me validation of these debts, you're going to want to keep correspondence such as that. Now, if the debt collection correspondence doesn't have specific language, now you as the consumer are entitled to know specific things about your debt. You're entitled to know where it came from, who it's owed to, and how long you've had the debt for. If the debt collection agency doesn't give you that information upon request, you as the consumer have a debt collection lawsuit. You're going to want to keep any and all correspondence that you believe is wrong. It's very simple. Anything that you believe shows your potential attorney that something was wrong, you're going to want to keep. Now, Florida has an additional statute called the Florida Consumer Collection Practices Act. That adds on to the federal statute we just discussed. That does not apply only to debt collectors. It applies to the original creditor. Now that's fancy word for somebody who you transact business with. So if you go to a hospital and you have a medical debt, that's the original creditor's debt. If the hospital sends you a collection letter that you don't believe you owe, or if they bill you instead of billing your insurance, or bill you in a circumstance where the law prevents them from doing so, you're going to want to keep documentation that shows your lawyer what they did wrong. This is going to allow your lawyer, again, to compile the data, analyze the information, and file a debt collection lawsuit.